people working from home are more productive than their in-office counterparts. And not just in low-skilled consumer call center workers kind of cases, but in highly skilled knowledge workers like attorneys, that people tend to log on earlier because they don't have a commute, to stay online later because they don't have a commute, to spend less time on chit chat and office gossip. And that the problem is not that people aren't working as hard or producing as much, but they maybe suffer from burnout because they're working too hard. That's his perspective. He also says, law firms can save a lot of expenses when you don't have to deal with as much rent or as much paper or as much toner or as much other expenses with people in an office. So that's his perspective. Whether it's going to happen that way or not, I'm not sure, but I suspect there are some things that we have done during this extraordinary last year that we will continue in the future, including there being more remote legal work than existed before. And they're probably going to be continuing Zoom meetings, maybe not for Law Club when we can actually all get back together in person, but for a lot of the work that we now do using Zoom. And with that, let me move on to the cases. And I want to start with a decision from just 1 week ago by the Indiana Supreme Court, an opinion by Justice Slaughter in the case of New Nello Operating Company, LLC versus Compress Air. That was actually a case that we talked to you about last May when it was before the Court of Appeals. And the Court of Appeals had kind of agreed with the position taken by the plaintiff in the case, Compress Air. Compress Air had done some work for this company, the Nello company, which was in the business of utility and cell phone towers. And they had installed some piping, and they were owed about $44,000, and they sued the company. And the company basically went out of business. That entity went out of business. And so they sought to hold the succeeding entity responsible, the new Nello company. And the trial court said that they could, and enter judgment for Compress Air. The Court of Appeals said that they could, basically finding that there was a de facto merger between the old company and the new company. But the Supreme Court takes a very different view of it and says that when they look at all their past cases on de facto mergers, in each of those cases, there was continuity of ownership. That is, the new entity had at least some, if not all, of the same ownership as the old entity. And in this case, the new entity has none of the ownership. It's got exactly the same senior management. It's got 90% of the same employees. They're at the same place and they're operating essentially the same business, but they don't have continuity of ownership. And basically the Supreme Court, when they look at this in this decision by Justice Slaughter, they say, well, the general rule is that when you have an asset purchase, the buyer acquires the seller's assets, but not its liabilities. Now, there are exceptions to those rules, and one of those exceptions has been the de facto merger. If you have a de facto merger of entities, then you may acquire its liabilities. But it says in order to have a de facto merger, as a result, and with a clear line, there's and therefore it's not a de facto merger. The other exception
that was I've been doing tons of.
Okay. The other exception that comes into play here is the one for a mere continuation of the seller. If you've got a new entity that is simply a mere continuation of the seller, that would also involve the extending the liabilities of the seller. But as to the mere continuation exception, the court says, in order for there to be a continuation under that exception, again, there needs to be a common identity of equity owners. And since there wasn't here, it didn't fit that exception either. So Compress Air is out of luck. It doesn't fit either of those exceptions. And you now have clear guidance from the Indiana Supreme Court as of a week ago that if you want to hold an entity liable, which is a successor entity that looks like the old one, and there may be a lot of things that seem very similar, if there's not continuity of ownership, you're probably going to fail. So that's the Nello case, the version. So you were told about the Court of Appeals case last May, you can disregard for now. Our next case is one that comes from the Court of Appeals, a decision by Judge Crone in the case of the Residences of Ivy Quad Unit Owners Association, Inc. versus Ivy Quad Development. And it deals with the economic loss doctrine, and it deals with a very important issue concerning that doctrine. And it it limits significantly what the Indiana Supreme Court decided in the Indianapolis Marion County Public Library case a few years back. And before I get into detail, let me advise you that there has been a petition for transfer of this decision, but I think we should all be aware of where the law stands now. We don't know for sure if the petition for transfer would be granted, but I'd say I put money on it. This is one where they're going to grant it in light of the holding of the case. And let me alert you to where this comes from. The plaintiff in the case is a homeowners association, owners of units in a condo development in South Bend. And apparently there were a number of construction defects associated with this development. And so the homeowners association decided to sue, and they sued first the developer, Ivy Quad Development LLC. And they certainly had responsibility for the building and the defects. Unfortunately, by the time all of this is happening, they are insolvent, kind of like the old Nello operating company in our last case. So the homeowners association needs to look to other entities that might be liable. And they sue not only the developer entity in the Ivy Quad Development LLC, which is insolvent, but they also sued David Matthews, who was in fact the owner of that entity, individually. They sued his wife, Velvet, individually. They sued the general contractor, Matthews LLC, which also is connected to Mr. Matthews, and the designer, DMTM, also a Matthews. All these, and so you've got defective construction, you've got one entity that would be clearly liable that is insolvent. Can you make the other defendants liable on tort theories of either negligence or a breach of warranty? And that's what was presented to the Court of Appeals in this case. And in a I think a well-written opinion by Judge Crone, he reviews the case, the status of the law, and notes that from that public library case, while the Indiana Supreme Court had taken a very broad view with respect to the economic loss rule in a construction defect case, it wasn't a construction defect case that involved, as the courts referred to it as, the sophisticated world of commercial construction, as opposed to residential construction, and where the different entities involved in that construction could, through contracts and the network or chain of contracts governing the project, protect their respective interest. Here, Judge Crone says, we don't have that in the residential context. And he points to language specifically in the public library case that caution, quote, there are situations where it would be unjust not to allow a plaintiff to proceed in tort for purely economic loss where no contract exists nor could exist between the parties. And interestingly, in deciding this case, he also points to the fact that when the Supreme Court decided the public library case, they had relied on language in a working draft of the restatement third of torts on the economic loss doctrine. And he noted that that language was substantially narrowed in its final version. So in terms of limiting the bar to negligence claims for economic loss to parties who have contracts. Obviously, there's no contract between these other Matthews entities and the homeowners association. So the court looks at the cautionary language in public library, at the change in the restatement, and it decides that it's not going to extend what it called the sweeping holding in the public library case to a typical residential construction context, and will allow a negligence claim, a tort claim, to be asserted against defendants who are in fact negligent, causing harm to these plaintiffs, even though it's just an economic loss and unrelated to a personal injury or a property damage, as that is understood. Now, there are a couple of other things that the court does in this case. First of all, it notes that this case came up on an interlocutory appeal. And on the interlocutory appeal, they sought simply to appeal the issue of the economic loss rule as applied to negligence. And when the court got it, it said, well, there's a breach of warranty claim here too. And once we certify an order for interlocutory appeal, we can address anything in that order. And so one of the first things it does is say the court had dismissed the breach of warranty claim. And the court said, well, when I look at this, when the court looks at this, on a 12b6 motion, by the way, the court first of all said, and I quoted this on page 7 of the handout, trial rule 12b6 is improper unless it appears to a certainty, and to a certainty is in italics in the text, that the plaintiff would not be entitled to relief under any, and those two words are also in italics in the text, set of facts. If I get a 12b6 motion against me as a plaintiff, I'm going to cite that with those highlighted from that case, just in terms of the standard for 12b6, the fact that they're highlighting to a certainty and relief under any set of facts, and the fact that the Court of Appeals does in fact say that yes, implied warranty of merchantability would ordinarily apply only to a builder vendor, and there's no question here that Ivy Quad Development LLC was a builder vendor. But there is a question as to whether they are the only person or entity that might qualify as a builder vendor. And I'm not sure about that. And so it reverses the dismissal of the breach of implied warranty of habitability claim. And then it also, it reverses the issue as to dismissal of the negligence claim, refusing to extend the public library application of the economic loss rule from a commercial construction situation and that sophisticated world to a residential construction. But obviously that's just the Court of Appeals talking. It's a case where I could expect, given the fact that the court is in essence limiting, expressly limiting a prior decision of the Indiana Supreme Court, and there are significant other voices being heard on this, that we may see transfer a decision by the Indiana Supreme Court in the not too distant future. With that, I'll turn it over to Brad.
And my first case is another case that we talked about last year when it was a Court of Appeals case. Transfer was granted, and now we have a decision from the Indiana Supreme Court. And it is the G&G Oil Company of Indiana versus Continental Western Insurance Company case. And if you don't remember, G&G Oil had a CGL policy with Continental that covered, among other things, commercial crimes, which were defined to include a loss that resulted directly from the use of any computer to fraudulently cause a transfer of property. Now, G&G Oil was hit with a ransomware attack that froze all of its computer systems, and it eventually paid the ransom and regained access to computers and made a claim with Continental. Continental denied the claim, because it concluded that G&G voluntarily paid the hacker. The hacker didn't take the funds, him or herself, and therefore it wasn't covered by the policy. So you had a deck action filed. Each party moved for summary judgment. Trial court granted summary judgment to the insurance company. Court of Appeals affirmed, and it goes up to the Indiana Supreme Court on transfer. And so on transfer, the court was focused on two questions. The first question was whether the ransomware attack constitutes fraudulent conduct under the terms of the policy. And the second one was whether the loss resulted directly from the use of a computer. So dealt with the fraudulent question first. And the parties argued about what exactly was meant by fraud. And Justice David, I thought, had a very good quote to say that, while we lawyers can make almost anything ambiguous, quote, if one were to squint hard enough, quote, end quote, that the term fraudulently caused a transfer is unambiguous and has a meaning that's readily ascertainable. And it's not the meaning of fraud that we normally deal with in the law. Instead, the court had a more dictionary definition approach to answering whether there's a fraudulent transfer. And the quote is there on page 8, but it eventually boiled down to, if you're going to say something fraudulently caused a transfer under the terms of a policy like this, then it's reasonably understood as to obtain by trick. And so if that's the test, that did the hacker get this Bitcoin from G&G Oil as a ransom, but did it obtain it by a trick? The court said, well, that's an interesting question that the parties haven't addressed yet. Because when it looked at G&G Oil's motion for summary judgment, and this designated evidence, it showed that G&G believed it was the subject of a spear phishing attack, but the court said that's not enough. Because, for instance, if there's no safeguards that you put in place to protect against this kind of thing, well, then, maybe there's no trick involved to getting in. And so it said we can't just hold that every ransomware act is necessarily fraudulent. And Continental also failed to meet its part of the test because the little that is known about what's going on, that there's a ransomware attack and G&G Oil's belief was enough to raise a genuine issue of material fact as to whether it was obtained by trick or not. So basically, neither party was entitled to summary judgment on that particular part. Now, that didn't end it because we have this directly part and whether it directly caused the loss. And the insurance company's argument was that the voluntariness of the payment shows that there wasn't a direct cause of the loss by this trick. And the court said, when we're looking at direct in this context, we're looking at whether the loss resulted either immediately or proximately without significant deviation from the use of a computer. And so that's how it looked at it. And it said that, well, G&G Oil's actions in this case, it got hacked, it had this ransomware, had its computer shut down, couldn't operate, consulted with the FBI and some other systems. And after that, it decided, well, we have to pay this money. And it said that these payments were voluntary only in the sense that G&G Oil consciously made the payment. And the court basically said this is more akin to duress than anything else. And so it's easy to say that, in the court's view, that the loss, the payment of that Bitcoin was resulted directly from the use of a computer. And so it found for the G&G Oil on that issue and remanded back to the trial court on the issue of whether everything was obtained by trick. So I think that particularly given the prominence of these kinds of attacks in the world today, anybody who has a CGL policy, it makes sense to look at it and to think about, for instance, what kind of safeguards can we put in place to meet that part of what the court pointed at is about what may be not fraudulent if you don't protect yourself. The next case I'm going to deal with is Lowry versus SCI Funeral Services, Inc. It's from the Indiana Court of Appeals, written by Judge Crone. And it deals with an injury that happened on a property. And I think Ron and I have discussed many times in the past couple of years this Goodwin case that came out of the Indiana Supreme Court dealing with premises liability. and the test that the Indiana Supreme Court announced for establishing the foreseeability part of a duty on this premises liability stuff. Now, this case addressed that, but in a slightly different context, and let me show why. The Lowrys were a couple who was at a cemetery in order to visit their internment site of their daughter. And this is about the 7th or 8th time they've been to the cemetery. And Mr. Lowry had a back condition that made it very difficult for him to walk on uneven surfaces like grass. And so they stuck to the sidewalk. And one part of the sidewalk came in like this and teed off on this circular sidewalk that went around the mausoleum. And when Donald was leaving, he tried to take a shortcut and cross over the grassy area of the tee, and his foot didn't quite make it all the way over the other piece of sidewalk. He slipped and fell into his wife and hurt them both. And the Lowrys sued Elm Ridge for negligent maintenance of the area in an unsafe condition, and had an expert saying that really there was too big of a drop off here. They should have known that people would be taking this kind of shortcut all the time, and that the failure to maintain this properly and have this erosion that caused a big drop off, the bigger than it should have been, was directly causally related to the fall. And it's unclear from the court's opinion exactly what the parties were arguing, but I suspect they were arguing the Goodwin factors, dealing with the broad type of plaintiff and the broad type of harm. The court said that there's some confusion as to the proper analysis, because with the question here, the good thing is when you're dealing with dangerous activities in the land, you may remember that some of those cases dealt with somebody getting attacked and beaten or shot at bars or other kinds of places. But here we're dealing with a dangerous condition on the land. And the dangerous condition issue, we should go back to the traditional analysis of, do you know of an unsafe condition? Do you expect the invitees will realize the danger? And could you reasonably protect the invitees from the danger? And if we look at that set of tests, well, here the danger was open and obvious. Mr. Lowry admitted that he noticed the drop off and he just thought he could make it and he couldn't. And so the court said, well, then there's no recovery here. And the Lowrys tried making another argument, saying that that there should be a heightened standard of care that cemeteries give, because they should know that most of the people who are coming to cemeteries are in a state of emotional distress and may not pay close attention to what's going on around them. And what I thought was interesting is the court didn't say outright, no, we're not going there. It did say, however, that theory was too speculative to apply in this particular case, leaving open the possibility that the court might accept that argument in the future. So that's something to look out for. Ron?
We next turn to another decision from the Indiana Supreme Court on an issue that I don't recall in the 17 years or so that I've been discussing cases with this group, ever discussing a witness separation issue before. But there is a rule in the rules of evidence that speaks specifically of excluding witnesses from a courtroom and provide certain exceptions that get a right to exclude them. But one of the exceptions is you may retain in the courtroom a person whose presence a party shows to be essential to presenting the party's claim or defense. Shows to be essential to presenting a party's claim or defense. And that's the rule that came into play in this case in Harris versus State of Indiana. It's a criminal case. A young boy who was 15 in 8th grade shot someone he thought had been stealing stuff from him, and was charged with attempted murder. It was heard in adult criminal court. And when he went to trial, he was 16 by the time he got to trial, he asked if his mother could be in the courtroom with him, that she would like to be there. And the issue, the court declined to allow that to happen. So the issue that was presented on appeal was whether the court was required to let the boy's mother be in the courtroom with him during this criminal trial. By the way, he got convicted and sentenced to 37 years for this crime. Initially, the issue was raised as a due process issue, presented to the Court of Appeals, not at the trial level, but in the Court of Appeals. And the Court of Appeals, in a split decision, said they thought it was a due process violation not to let the mom be in the courtroom with the child. But the Supreme Court granted transfer. And the primary issue before the Supreme Court was whether this was a case that satisfied Rule 615 exception for a person whose presence a party shows to be essential to presenting the party's claim or defense. And the court could have said, as a matter of just automatic, if you've got a minor, a parent ought to be allowed to be there. But the court didn't take that approach. It said the rule says that requires a party to show that this person to be essential. And there are lots of ways it might be shown with respect to a parent. It may be a child with special needs or struggles to communicate with counsel, or may need parental guidance to make life-altering decisions like whether to pursue a line of questioning, take the stand, or accept a plea agreement. But none of those were shown here in the trial court. And until it's shown in the trial court, there's no requirement to allow the parent to be present in the courtroom, a parent who's a witness, and there is an order for separation of witnesses. So it did note, by the way, if it hadn't been heard in adult court, in juvenile court, the child does have a right for a parent to be present, and the due process issue was held to be waived because it hadn't been presented in the trial court. So this conviction was affirmed, and we've got a little more guidance as to how the witness separation order is going to apply to children, which I think may also apply in lots of other settings where one party may want to have a person in the courtroom, and it may be an expert witness, or in a criminal case, it may be a detective. The rule basically says there needs to be a showing that that person is essential to the presentation of the claim or defense. So until you want to agree or be required to agree to such other people being present who are witnesses, you might take a close look at that and consider this precedent. Our next case is a case back to the Court of Appeals that involves an issue of indemnification. Not indemnification by an insurance company, but indemnification of a general contractor by a subcontractor. The case is Road Safe Holdings, Inc. versus Walsh Construction Company. And it arose with a kind of a typical accident involving somebody driving through a work zone. There's an accident. The driver is injured. He sues the general contractor, who says basically it's because of the subcontractor, and the general contractor asked the subcontractor, Road Safe, to indemnify it. Road Safe refuses. The general contractor, Walsh, third parties in Road Safe seeking indemnification. And Road Safe continues to resist. If you were an insurance company, you would understand in that setting that if you were, you either need to seek a declaratory judgment as to what the coverage is, your indemnification obligations are, or you need to defend under a reservation of rights. You can't just ignore it. But this subcontractor ignored it, and on the Court of Appeals says, we're going to regard the subcontractor in exactly the same way we regard an insurance company. If you get requested to indemnify and you've promised to indemnify in a contract and you don't, the general contractor can make a deal and settle as he did for $60,000. And whether there's any actual proof that the subcontractor, Road Safe, was negligent, that's irrelevant, because that issue has now been effectively waived. You cannot defend on that. You have to get that determined either by a declaratory judgment action or defend under reservation of rights. Since you didn't, you're accountable. And not in this case, just for the 60 grand that was paid to settle the driver's complaint, but also for the attorney's fees that were incurred as a result of that, and for prejudgment interest that accumulated in this case. Court, the subcontractor argued basically, well, we didn't know how much those attorney's fees were going to be. That's not ascertainable at the outset. And the court said it's not that it has to be ascertainable at the outset, it's at a particular time. And the attorney's fees were ascertainable at a particular time, and prejudgment interest would be allowed on that as well. So some cautionary table, or a cautionary case for anybody who promises to indemnify. With that, I'll turn it back to Brad.
My next case is Branscombe versus Walmart Stores East, and it's one of those rare things where the Indiana Supreme Court gets to answer a certified question from the federal courts. And in this case, you had a gentleman named Branscombe who was shopping in a Walmart, and while he was there, tripped and fell over a pallet and hurt himself. So he sued Walmart, but then he also sued the store manager, who was an Indiana resident, and he sued him in state court. Now, defendants argued that there was fraudulent joinder and removed the case to federal court. And when they did the removal, they presented an affidavit from Clark that he was not working or physically present at the store that day, and that he did not control the store's safety policies. The court certified the question of whether Clark could be liable under those circumstances to the Indiana Supreme Court. And so Branscombe argued there are three different theories that he had as to why there was liability here by Clark. The first one was negligent hiring, supervision, and training. And so the court dealt with that one first, and it said that these kinds of claims are really only available against employers, not against co-employees, even if that co-employee was a manager. And so given the limitation on those claims, there is no ability to state a claim against Clark for negligent hiring, training, or supervision. And really the same held true for the second theory, which was improper safety policies. Because here you had that affidavit from Clark, and the plaintiffs didn't present anything in response. So the only facts you had was that Clark did not have the discretion to unilaterally determine safety policies for the store, and that he had to defer to his corporate superiors. And the court said, well, in that case, we really can't conclude that Clark could be liable. Instead, it would only be his employer that could be liable. So then the court turned to the final theory, which it called the meat and potatoes of the plaintiff's claims against Clark, which was a failure to inspect and maintain the property. And so the court said that this kind of claim is we're going to look at the restatement, and we can see that it's generally limited to the owner or possessor of the land. And Clark was neither of those. However, the law allows the employer Walmart to delegate authority to Clark that could create that duty to the business invitees of the store. But the court said there were problems with that in this case, because first, this delegation of duty couldn't apply to Clark on the day of the incident because he wasn't working that day. Therefore, he couldn't have had been in occupation of the land with intent to control it when the accident occurred. But the court found more fundamentally that there was this inconsistency with the delegation idea and this kind of store manager relationship, because the court said when there is a delegation of duty like this, then the one who's doing the delegating doesn't owe a duty anymore. It's only the other party. And that in this case, it's the court said that basically it found it difficult to imagine, without using those words, a situation in which one of these big box retailers is going to delegate sufficient authority to a store manager under the law to have the store manager have the duty rather than the store, because the store is going to ultimately want to be able to come in and control the premises itself. And so that was also not going to be a positive result for Branscombe in this case. Now, interestingly, when Branscombe was making these arguments, He pointed to a number of sections in the restatement of agency that he said that would allow Clark to be liable. And the court addressed one of those, but it disregarded it because it said that there is no record that Clark took control of the store or that anyone, including the Branscombs, relied specifically on him to ensure the store was safe. And it didn't address these other restatement of agency arguments because it said they haven't been adopted by an Indiana court, which I thought was an interesting argument, and frankly, one that I can see people who are dealing with restatement arguments, especially novel restatement arguments, making to both trial and appellate courts in the future. You haven't adopted this yet, and this shows that it's not adopted. There's no reason to do so now. And so I think that was an interesting outcome of that particular issue in that case. Yet another Indiana Supreme Court case, because they've been busy, is my next case, the City of Bloomington Board of Zoning Appeals versus UJ80 Corporation, which deals with definitional sections of zoning codes, in this case, Bloomington zoning code. Bloomington, unsurprisingly, allows buildings to be used as fraternity or sorority houses. But in 2017, it amended its zoning ordinance to say that these buildings are only qualified as a sorority or fraternity if IU sanctions or recognizes that it's a sorority or fraternity. Now, UJ80 bought a piece of property in Bloomington in 82, has owned a fraternity or sorority house there ever since 84. And in 2016, it started renting the property to the TKE fraternity, TEEKS. However, IU sanctioned the TEEKS and revoked their recognition in February 2018. And most of the members of the fraternity left the property at that time, but 2 people remained. Bloomington told UJ80 that they had to leave because they were no longer lawfully a residence under the zoning ordinance, and UJ80 didn't like that. So they unsuccessfully appealed the decision to the Board of Zoning Appeals, but then successfully sought judicial review, which was affirmed by the Court of Appeals. And the issue was whether there was an unlawful delegation of zoning authority and whether there was a regulatory taking. The Supreme Court granted transfer on the unlawful delegation issue. And it said that in this case, using a definitional section like this, saying it is not a delegation of authority to a third party on what is legal and illegal under the zoning law. It says that there's a lot that ordinances, many other definitions and ordinances reference an outside entity, and that the ordinance in this case merely defines certain land uses based on their relationships with relevant outside organizations. And while the ordinance's definition recognized there was broad authority that IU had when determining whether a sorority or fraternity was sanctioned by the or recognized by the university, that it did not obligate IU to act with regard to any of these issues, or empower it to write zoning law, so that without that kind of specific authorization, that there was no delegation. Now, it did recognize that letting a third party make this kind of decision does have what the court said was collateral effects on the zoning scheme. But it said that in this situation, I mean, IU was it is a state entity, and its regulation of sororities and fraternities is a quasi-judicial process, it said, with a disciplinary process, and that there's due process that's allowed there. And if UJ80 really wanted to protect its lease, it could have supported the fraternity during those proceedings, which it did not do. And I wonder if if it had been a private university or something like that, whether the outcome would have been different if there hadn't been those same kinds of due process things in place that IU had for the fraternities and the sororities. My next case is Stat versus Indiana Department of Transportation. It's from the Indiana Court of Appeals. And it deals with really summary judgment issues when it comes to statutory immunity. You had Mr. Stat, who was driving on I-74 on a rainy day. His car hit a puddle, hydroplaned, he went off, hit a tree, and injured himself. He sued INDOT, arguing that the highway had been negligently maintained, and INDOT moved for summary judgment, arguing that the puddles on the highway were a temporary road condition. And indeed, the statutes immunize the state against losses from a temporary condition that is caused by weather. And so the trial court granted INDOT's motion, and the Stats appealed. And so the question on appeal are these puddles on a road temporary condition caused by the weather? And in this context, the case law had said that a condition is temporary, that the government is not liable if the condition continues to worsen or is still evolving because it hasn't stabilized. And the Court of Appeals expressed its displeasure with this particular rule. There's another panel that in January gave a decision dealing with the same issue, and this panel agreed, saying, among other things, that the current analytical framework not only allows for the state to be negligent, it encourages it, because the state had no incentive to attempt to implement remedial or preventative measures regarding such conditions. Now, it said we're still going to follow the law, we just don't like it. So then it applied the law on this stabilizing issue. And of course, INDOT's argument was, well, it's raining, so it hasn't stabilized. And the court said, well, we're not so sure about that. Because the court said, if you look at puddling, well, puddles can only fill up so much. And there's a reasonable inference that if the puddle had formed at some point prior to the collision, any new rainfall is just replacing the water that's there. The condition is the same. It had stabilized. And so therefore, INDOT hadn't shown that it was unable to place warnings or close roads, and it said that this fact there's puddling means it's stabilized, and therefore, or at least a general issue as to that, and that we can't grant summary judgment. Now, that didn't end things, because INDOT was also saying it wasn't negligent, and it argued that because it said, well, the stats didn't give us notice that there were puddles there. And that was the evidence the court relied on to say that it didn't have notice of this dangerous condition. And the court basically said that that's not enough. That saying that the plaintiff didn't give the state of Indiana or INDOT notice of these puddles. The state of India has a lot more resources than that, and knows about the state of that road in general. And so that kind of evidence wasn't sufficient for summary judgment purposes to show that the INDOT lacked actual or constructive knowledge of the puddling. So therefore, INDOT didn't do enough under the standard that the court didn't like in order to demonstrate that it was going to be immune from suit. Ron?
Our next case involves the calculation of attorney's fees when you can ask the other side to pay for it with a fee shifting statute or for some other reason. The case is Wilder versus DeGood Dimensional Concepts, Inc. And the prior course of the litigation involved an assertion of a claim for unpaid salary, commissions, vacations, sick time, and bonuses on behalf of Wilder versus DeGood. The claim was successful on the merits. He didn't get all the compensation that he was entitled to. There was then a fee petition for $50,000 to cover an initial trial, an appeal, and a remand, which didn't seem like that much, but there was some resistance to that. And the trial judge, in looking at the hourly rates that were being charged, thought that the claim for at the rate that was being requested was too much. And he says that, well, that hourly rate that you're asking for, Mr. Weldy, is too high. That may be fine in Indianapolis federal court, but it was too much for Kosciuszko County. Instead, he said, well, $300 an hour was what he's going to allow. And then he commented that even though my colleagues believe that down the hall, that's too high a rate. But he said, I get to set the rate in Kosciuszko County as far as I'm concerned. That's what he did, but the Court of Appeals didn't agree with him in terms of what he gets to do. The court basically said, yes, it is the case that a court may take judicial notice of prevailing rates for attorneys in their counties, but that authority is limited. It is limited to routine cases involving relatively small amounts. And when it's $20,000, that's not a small amount. And an award of over $30,000 for a case encompassing almost a decade is also not a small amount. And therefore the court said, the trial court can take judicial notice when it's a small amount, but not in a case of $1,000 or more. Here, the evidence of record was that, that for this kind of work, the hourly rates were $385 to $500. And when the Court of Appeals looked at it and said, the smallest that we can see here is $400 per hour for the appellate work that was involved. And that's what the court ordered that be paid by the defendant in this case. So this notion of the trial court having complete discretion is clearly in jeopardy under this rule. There needs to be a record. And so if you're asking for fees, make sure you provide evidence as to the appropriate reasonable rate. If you're resisting it, you think it's too much, you probably ought to present records to the contrary. You think the judge would be willing to provide less, but it's not something that is in fact simply left to the discretion of the trial court based on judicial notice of prevailing rates that the trial court has when you're dealing with larger sums of money. So an important case in the attorney fee areas, in the attorney fee area. And our next case also deals with attorneys, but in a very different context. It's a disciplinary case brought against Michael Blickman, an attorney at Ice Miller, in which a number of allegations were made arising from a serious case out of Park Tudor involving sexting by an instructor / basketball coach with a 15-year-old girl that led to that instructor to be sentenced to 14 years in prison on federal criminal charges that followed. The headmaster at the school committed suicide shortly after these things unfolded. And then Mr. Blickman was apparently fired by Park Tudor for his role in the affair, which was much less serious apparently than either obviously the teacher or the headmaster. What he did was provide some advice. When the father of the child came to the headmaster called in Mr. Blickman. They met and they talked about how they were going to deal with this situation. There was discussion about some sort of settlement agreement with a confidentiality provision and discussion about reporting to DCS. And without getting into all of the details, it's a lengthy opinion. And I think we, in fact, cover about 4 pages of our handout with details about this. Bottom line is, Supreme Court decides that Mr. Blickman is not responsible for several charges that the disciplinary commission has brought, but they do find that he has violated Rule 1.1 of the Rules of Professional Conduct, the rule that says a lawyer shall provide competent representation. And they say that he didn't provide competent representation when he worked with the headmaster, Miller, regarding these settlement negotiations and trying to, in essence, as the Supreme Court saw it in this per curiam opinion, trying to silence the child on a going forward basis and information leaking out about the details of this apparently scandalous incident. So that was the incompetence that was discussed in terms of trying to work on a confidentiality provision of a settlement agreement with the family. He was also found to have violated Rule 8.4, engaging in conduct that is prejudicial to the administration of justice by not trying to fully provide information to police authorities and DCS about the details of this incident. As to both of those violations, the court simply imposed a public reprimand. There was no other suspension or other thing that was requested by the disciplinary commission. This was, as I say, a per curiam opinion. There was a dissent. Justice Slaughter dissented from this decision. He didn't think it was improper for Blickman to include a confidentiality provision in the proposed settlement and did not blame him for being in an untested legal position. He also didn't think that those efforts were, quote, a major deviation from professional standards, which is what has historically been required for a finding of a violation of Rule 1.1 to provide competent representation. He was also concerned about sanctioning Blickman for negotiating provision that is contrary to public policy. It's one of the things the court held, that this confidentiality provision to kind of keep this secret was contrary to public policy. And the court, Slaughter was concerned that there are lots of times and places when lawyers are involved in negotiating contract provisions that are held to be in violation of public policy. The geographic limitations in non-competition agreements, liquidated damages clauses, exculpatory clauses in residential leases. If that amounts to a disciplinary or a violation of the rules of professional conduct, he says anybody who drafts those kinds of provisions may be subject to such disciplinary action. It is a decision that obviously has implications for all of us in lots of different areas. And you might want to pay attention to it as we try to understand better how the rules of professional conduct are going to apply in certain circumstances. One of the circumstances, by the way, that the court did not hold him responsible for dealt with the issue of reporting to DCS. One of the things that Headmaster Miller had asked during that initial conversation was whether they had to report it to DCS. And Mr. Blickman acknowledged that he didn't know exactly, but he would have to research it, which he did. And at 7 a.m. the next morning, he advised that they would need to report the allegations to DCS right away. The other issue dealt with whether he needed that expertise in the first instance. And the court said, we do not demand perfection or even specialized expertise, and recognize that preparation and research frequently will be necessary to meet the needs of the representation. And one other, I guess, important point from my perspective dealt with confidentiality, because the question was raised as to whether he should have called DCS. And the court noted that there is, in fact, a report from the Indiana State Bar Association Ethics Committee that basically says when you obtain information as part of a representation of a client, that information is confidential. And in the absence of somebody, imminent death or serious bodily injury to somebody, you've got to keep it confidential. So then the question is posed, or do you have nonetheless a duty to report it to DCS? And the court doesn't really resolve that question. But the reality of Rule 1.6 and Comment 3, that the confidentiality rule applies not only to matters communicated in confidence by the client, but also to information related to the representation, whatever its source, I think should all give us all pause as to what we can tell DCS or anybody else in certain circumstances, given what the ethics committee has said and the confidentiality rule as it's written. With that, I'll turn it back over to Brad.
I don't have a lot of time, so I'm going to rush through these last couple of cases that I have. The first one is Albany's Confectionery Group, Inc. versus Quick. Basically, there you had a woman who had her cell phone tied to the company's email. When she agreed to do that, she signed this agreement that said that they could wipe the phone if they needed to. She was fired. They wiped her phone. She got mad. She sued. And the Court of Appeals basically said, no, there's no claim here. That contract was enforceable even after you were no longer working there, because it wasn't an employment contract. It was an agreement to protect the company's proprietary data. One interesting was interesting about this case is that the company moved for summary judgment on whether it was entitled to fees under the general recovery rule for frivolous litigation. And the court said that while certain aspects of the employee's claims are concerning, that there were issues of fact that precluded summary judgment, but didn't describe that at all and what those issues were. And so first, I thought it was interesting that it'd be subject to summary judgment. And second, I thought that it was interesting there'd be issues of fact that prevented given the court's decision. So it's something to think about if you have to deal with litigating that kind of issue in the future. My last case is Newell Inc. versus Marcelet. In the handout I put, it's a bird in the hand is the title, because, a bird in the hand is worth two in the bush. You have some people that own some property and they put it into trust, this commercial property. And they also owned a corporation that the property was leased to, but they leased to the property of the corporation in their own name rather than in the trust's name. And so they got insurance. The insurance only covered your financial interest in the covered property. Well, there was an accident. They got paid partially on the coverage and partially not. Filed a lawsuit, and then the insurance company got a hold of that lease and said, we don't have to pay you anything. And it basically came down to, yes, the insurance company's right. They didn't have to pay anything because the court said, we have certain formalities that have to be required. And if a trust owns the property, even if the trustee and the beneficiary are the same person and they sign the lease, and they don't do it in their capacity as trustee and do it in their personal name, then it's an invalid trust. And so there were a couple other issues in that case that were related to that, but that was the basic message. Ron?
And our last case is one that deals with informal settlement agreements, and essentially the Court of Appeals held in Jet Service Company Inc. versus Ellis Ventures that if the essential terms are there, and here the essential terms were in an email exchange where one party offered to settle for $8,000 and the other party reluctantly agreed. And then there was going to be an agreement made later. The court said the essential terms are there and we're going to enforce it, even though there was never a signed written agreement. So informal settlement agreements are enforceable if, in fact, you make it clear at the time of the original exchange that it's not, nope, there isn't binding until there's a formal written agreement, then it's not going to be enforceable, but that wasn't the case here. And finally, as usual, I end with an advocacy tip of the month. And I don't know about you, but getting jury trials has been impossible for the last year or so. I thought I was going to have one last month or last week. It got continued shortly before that. But it occurred to me that it's been a long time, and some of these basic rules of trial advocacy, memory kind of lapses. And so I thought you might enjoy what Alex Tanber's written about the basic rules of opening statement as we hopefully return to jury trials soon. And he provides, I think, some pretty helpful, straightforward guidance on that I give to you. And with that, I think we're done. Libby, do we need anything more this afternoon?
I don't think so. If it wasn't exciting, it was at least a lot of ground that was covered. So as always, thank you so much, Ron and Brad.
Give us the exciting.
Thank you, Libby. Thank you.
Thanks all.
Thank you.
Good work, guys.
Thanks.